Okay. On the record in the matter. Oh, I'm sorry. Is Addie at the computer?
1 second.
Oh,
Yes,
okay.
Judge, she said just a moment.
No problem.
I can't hear the recording.
You what?
I can't hear.
Are we on the record in the courtroom?
No, Judge, Addie's recording equipment wasn't working. She couldn't hear anything. She just left to go try to get some assistance.
Okay, sounds good. Just let me know when she's ready.
You got it.
Mr. Harding sleeping?
Well, I'm kind of tired, but I'm okay, I promise. Sorry, ma'am.
Okay, no problem.
Judge,
Yes, sir.
sounds like Addie's in business.
I can't hear you.
I think Addie's good to go.
I was gonna hope so, because I saw at least 3 court reporters in there. Okay. Let's see. Mr. Hart, you can still hear me.
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Robert Edward Hart, file number 21-03090 council appearance. I can't hear the council appearance. Can you hear me?
You're gonna have to say it again. It was muted.
She's not gonna give her.
No, you have to do it. It was me. It was for you.
Oh, for me, I'm sorry. Assistant Public Defender Sarah Donnelly on behalf of Defendant Robert Hart, who is appearing separately by Zoom.
Thank you. Today's sentencing, I do have a pre-sentence report and recommendation. Ms. Donnelly, you should get a copy of that.
I did, Your Honor.
Have you had an opportunity to review it with Mr. Hart?
I have, Your Honor.
And is there any reason for us to make changes, updates, or corrections?
Only one, Your Honor. It seems like someone else's assessment got thrown in here on page 27 through 37. I don't believe that these are in reference to the defendant.
That is correct. Any additional changes?
No, that would be it.
Okay. Okay, you can make your allocution.
Thank you, Your Honor. We don't, in regards to the recommendation, we don't have any objections to the probation department's determination that Mr. Hart is of high risk to probation. The recommendation or the report stated that though they do recommend Mr. Hart for a term of probation, they do recognize that he is at high risk. He had in the report, it was the mental health aspects of complying with probation that they were concerned with. I believe that Mr. Hart, in that regard, it would not be as hard as maybe the financial obligations, because since he did get the assessment, part of his deal for the plea was that he was to get an assessment and treatment for substance abuse and mental health. Mr. Hart, since the plea, has on his own gone to Cristo Rey and gotten an assessment, and he has now engaged in treatment there. So he is seeing Ms. Beverly Boatley at Cristo Rey. He's had 2 sessions with her so far. He's described her. He likes her. He says he appreciates that. She says she calls him out on his bullshit. But he also he respects her because she doesn't judge him. He's had problems with therapists in the past, like I guess actually laughing at him. So he appreciates Ms. Boatley. And it sounds like that is going to be a very beneficial therapy relationship. Also, Ms. Boatley is they've gotten Cristo Rey offers a lot of services, so he's got a referral for a marriage counselor. He's looking into CBT. He is also, Ms. Boatley is writing him a recommendation for an emotional support animal, because he does struggle with a learning disability. He completed the 6th grade. He does say he reads pretty well. It's just numbers are a problem for him. And he has PTSD and bipolar disorder. So those are the obstacles he has to get into control with. But I think he's on the right path to that. I think that if he's engaging with treatment at Cristo Rey, he's very motivated for that. So I believe that he is halfway to completing what he was what he was going to be ordered to do today, which was get screening and treatment for substance abuse and mental health. The assessment though gave him a low substance abuse, so I believe that they're focusing on any mental health that he might have. So the risk to substance abuse was low, I believe. So they're focusing on the mental health. Besides that, Your Honor, he's born and raised in Lansing. He has a relationship with one of his sisters. He has hobbies. He likes remote control cars and airsoft. He was released from prison in 2019. He's married with 2 kids. He's known his wife for over a decade. I believe that if you remember, she was a very good advocate for herself and her husband. The last time that we were before you, she seemed very capable. He has financially, he can't work. He was on disability in his 20s for his learning disability, but when he went to reapply recently, he was denied. He had an attorney for the appeal, but that attorney had retired, so he has to start all over. So he is it's going to be very limited what he can provide financially. I think his whole family is on government assistance. But other than that, we don't have any, we wish that the court would put him on a term of probation and understanding, but just long enough in understanding that he needs to continue his mental health treatment but also if the court would consider how to best make sure he succeeds on probation, because he's at high risk of probation. He might not, the risk is there, but if we can tailor the conditions in a way, I believe, so that he can succeed. Thank you, Your Honor.
Okay, I'm not sure that I'm following what you mean when you say tailor the conditions so that he can succeed.
Well, Your Honor, I do know that the recommendation was for a lengthy term of probation, 18 months. Just knowing that I just wanted the court in deciding sentencing to consider when setting how long he's going to be on probation. What he's already done, and he's committed himself to treatment at Cristo Rey, and that he will have those financial difficulties, and I don't want those to be a hardship. I know he's terrified of violating probation because if he can't pay for something. So I just wanted the court to consider those facts when sentencing. Thank you.
Well, okay, thank you. Does your client want to make a statement at all?
No,
Mr.
Your Honor, I
Hart,
don't
did you want to
believe
make
he
your own
does.
statement?
Yes, ma'am, I do. Since going to Cristo Rey, I've noticed a few different things about myself that I definitely could stand to change. CBT will be a big benefit for me and my family in order for me to make the changes that I know that I need to make with my mental faculties and everything that I deal with on a daily basis. And as far as the hardship for being able to pay like probation costs and monitoring costs and everything else, that would be a financial burden for me. Being that I don't feel safe in a workplace due to my bipolar and PTSD problems that I have been having, I don't want to put other people at risk and end up with more problems than a misdemeanor disorderly now. I'm currently working with 2 therapists at Cristo Rey. One is trauma-based. He'll be sitting in on certain sessions when me and Miss Beverly get to talking about the things that have been severely traumatizing for me in my past. And then just not long ago, since I've been out. But I just don't want to fail this probation.
Oh. Thank you. I don't want you to focus so much on failures. Focus on something positive. Focus on the possibility of being successful. Focus on the possibility of getting the treatment that you need so that you can be there in a positive way for your family. You want to be able to show up for yourself and for your family, for your wife and your children. If you're focusing on the possibility of failure, that's the direction you're gonna start gravitating towards, okay? So I don't want you to focus on those things, sir. Do you understand that?
Yes, ma'am.
So I've had an opportunity to review the pre-sentence report, the recommendation, and your prior criminal history, and I understand that this matter was reduced to a non-serious misdemeanor, that being a disorderly, but the court is very concerned about your mental health and your wellness. And I applaud you for doing what you needed to do to re-engage with some services so that you can address those things. I do not want to put you in a position that would leave you without any court supervision to make sure that you're staying consistent with your treatment. So I'm ordering a term of probation, or I'm going to order a term of probation, just because I want the court to be able to monitor to make sure that you are continuously engaging with your mental health therapy and any other treatment or recommendations that they're providing. You understand that, sir?
Yes, ma'am.
Okay, so I am not going to, I don't think that a term of 18 months is necessary at this time. I'm going to start you out with the term of 9 months of probation, okay?
Okay.
While on probation, you need to continue to engage with your treatment, with your therapist at Crystal Ray, and you need to follow all of their recommendations. Do you understand that?
Yes, ma'am.
And you're not at all engaged in community mental health at this time?
I'm engaged with with Crystal Ray Mental Health. Up at
Okay,
Crystal.
but not community mental?
No, ma'am.
Okay, is there a particular reason why you're not engaged with community mental health?
Past bad experiences that for me were to the point where I wouldn't go back to talk to them.
Okay. Okay. I'm going to place you on a term of non-reporting probation, okay? So you're not going to be incurring the $30 per month oversight fee, so you don't have to worry about that. You're actually just going to be, at the request of the probation officer, providing proof that you're still continuing your treatment with Crystal Ray, okay?
Yes, ma'am.
While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapons of any kind. You're not to use, purchase, or possess alcohol, marijuana, or any controlled substance unless you have a valid prescription. Do you understand that?
Yes, ma'am.
Have they recommended that you engage in any continued education so that maybe you can complete your education?
No, well, they asked, but I don't. Again, it kind of goes back to the learning, me being having the learning disability and PTSD. I don't want to like get frustrated and end up getting kicked out of a class or possibly anything else.
I can imagine that. So I'm not going to order that, but if that's a recommendation that they're giving, if you made enough advancement in your treatment that they believe would be beneficial for you to engage. I mean, there's a lot of opportunities for you to engage remotely to continue your education, but I can assure you, if you want to secure some long-term success, you might want to get beyond a 6th grade education, okay?
I will definitely work on it. I give you my word on that.
Okay.
I will.
Very good. So right now you just focus on the treatment, and I know you have 2 therapists, so they'll provide you what they believe is the best course for you to proceed on. We just need to make sure here at the court that you're following their recommendations and you're continuing to report to your therapy treatments, okay?
No problem.
There's an advice of rights as to probation. It says you have the right to request a hearing for early discharge from probation once you have completed half the original term ordered by the judge. You must file a motion for early termination of probation with the court. You understand that, sir?
Yes, ma'am.
You cannot request a hearing for early discharge until all rehabilitative requirements have been completed and there have been no probation violations within the 90 days preceding your request. Do you understand that?
Yes, ma'am.
You have the right to hire or retain an attorney to represent you if you need a hearing for early termination. You do not have the right to a court-appointed counsel if a hearing is necessary. Do you understand those rights?
Yes, ma'am.
Lastly, if you are on probation for domestic violence, stalking, criminal sex crime, human traffic violation, or an offense where the defense was asserted of guilty but mentally ill, you are not eligible for early discharge from probation. You, sir, are on probation, non-reporting probation for disorderly person, okay?
Yes, ma'am.
So you can request in writing for the court to consider early discharge after you've completed half of the term that I'm ordering, which is 9 months. So after about 4.5 months, if you've been consistently going to your treatment and you're doing well, you can get the paperwork from the probation department and they'll provide it to the court, okay?
Yes, ma'am.
Do you have any questions right now regarding your probation status?
No, ma'am.
As to fines and costs, there is a $75 crime victim rights fee that will be assessed. I'll waive the state minimum cost. Do you have any questions?
No, ma'am.
Any additional matters for the record?
No,
No,
Your
ma'am.
Honor, thank you.
Thank you. You're all set, Mr. Hart. Good luck.
Thank you, ma'am.
Thank you.
Is anyone else in the Zoom?
Okay, so let me see here. Good morning, Mr. Newberg.
Good morning, Your Honor. How are you?
I'm good. How are you?
I'm good, thanks.
Which matter are you here for? Is it Evan Melville?
It is.
Okay. Is he going to log in around 9:30?
He said he would be logged in about 10 minutes ahead of time. I assume he's not in the waiting room.
There's no one in my waiting room at this time.
Okay, let me shoot him a quick text here.
No problem. And Mr. Newberg, did you need to speak with the prosecutor at all?
No, I'm all set.
Okay, how are we proceeding today?
I received an email from the prosecutor, excuse me, indicating that there
I
wasn't an
just
offer.
briefly, because we're not on the record, I just need to know if we're doing a plea or we're resetting it.
I'm just going to ask if the court would be okay with setting it for another pretrial in about a month. My client is in some services now, and that'd give me some more time to talk with the prosecutor's office.
Okay, that sounds good.
Thanks.
No problem. Who just joined me from the iPhone?
Here, did you got me in the video now? Okay.
Okay, is that your client?
It is.
Okay, sounds good. Ms. Lacy, is there anyone in the courtroom? My staff,
Mr. Bigelow is here.
Mr. Bigelow, can you give him a new pretrial date? How much time did you need, Mr. Newberg?
I think a month would be fine, Your Honor.
To April 12th at 9:30.
That work for you?
That works.
Okay, well, we set this for pretrial April 12th at 9:30. You're all set for today unless there's anything else.
Nothing for me. Thank you, Your Honor. Have a great week.
Thank you. You have a good one. Same to you, Mr. Melville.
Thank you. You too.
Thank you.
Did you get one?
Okay, do we know what happened to the other 9:30 people? Leanne
Nobody here,
Barrett,
Judge.
you said what?
There's nobody
Mr.
here.
Biggle, you
but
know,
Mr.
you're not in a mic, but what?
Judge, we can't hear you. You're going in and out like every other word.
You can hear me now?
Yes, ma'am.
Okay, you said there's nobody here, but what?
Correct. There's no one else here, but Miss Barrett also had a matter at 10:30. I don't know why they were scheduled at two different times, so perhaps she'll show up then, but I don't know.
Okay, anybody know where Alicia Warren is, or have they spoken to their
I'm
client?
trying, I talked to her yesterday. I was just gonna have it adjourned because I'm still trying to get video, but I don't know why she's here, so I'm gonna try to call her.
Oh, you did speak to her yesterday, though?
Yeah,
Okay, I'll give you, you can get the new date.
okay.
How far out?
Just another 30 days. I'm getting run around from Subway. My investigator has tried, and now I'm gonna try to just get Ms. Warren to see if she can make any headway.
We can do April 12th at 9:30.
April 12th, 9.
For which one?
Warren.
Warren.
And what about Tyler Fisher?
Your Honor, I did reach out to Mr. Fisher yesterday. However, I have not gotten a response. I do know he's got some other matters pending in the 55th District Court. It appears he appeared for those and handled those hearings. I don't know if there was some confusion as to dates, but I haven't been able to get in touch with him.
Okay, we'll issue a bench warrant, but we'll hold it for 48 hours.
Thank you, Your Honor.
No problem. And then we'll see if Miss Barrett shows up at her next court. All right, who's on phone number ending in 0630?
Yes.
What's your name?
Julie Medellin?
Okay, Ms. Medellin, did you receive instructions on how to dial in with a video?
Yes, I did.
Okay, you have to have video or you have to come in person, ma'am.
I can't do it through my phone?
You're on your phone, but I can't see you.
Oh, okay. I guess I didn't read this correctly. I thought this is what I had to do.
I think you just dialed in, but didn't add the video. Did you download the app for Zoom?
I have, let's see. Okay, I have the Zoom app, join meeting, and then the ID number I put in
Mm-hmm.
for,
Did it give you an option to join with video?
let me see. Oh, it says connecting right now.
Okay.
Here we go. Dial in. Here we go. Whoops.
Now you just need to start your video.
Okay. Let's see.
It
Nope.
may look like a little camera or camcorder icon on your screen. It should say start video.
Okay. I don't know what I just did wrong. Is FaceTime. I'm scared if I hit the hang up button, it's gonna hang it up.
No, you're where you're supposed to be. Don't hit the hang up button. And oh, you must have left the video. The video logged off. Your phone is still there. Are you there, ma'am?
Yes, I'm here.
Okay. Do you have options though to start with video?
There's not that option. It's your regular contact
Okay.
FaceTime.
In Zoom? You need to be in the Zoom app. You shouldn't have a FaceTime option in Zoom. Okay, she might have disconnected by accident. I need to share my screen so she can start her audio for Julie.
Hi, okay, now I can hear you.
Okay, excellent. Okay. Who represents Miss? Oh, Mr. Seeley is here too. Who represents Miss Decker?
Myself,
Ms. Decker, you're representing yourself?
yes.
Okay. And then is anyone representing Julie Medellin?
Oh, I'm sorry, yes, you cut out for a second, I thought that's what you said. No, I'm
Oh,
representing
okay.
myself.
Thank you. What
Yes.
about Ms. Decker? Ms. Decker, do you have an attorney?
I'm also representing myself.
Oh, okay. Ms. Lacy, do you still not have any internet service?
No, we do now.
Oh, okay. Do you want to log in to speak to these individuals privately?
Yep, that's fine.
Okay.
Go find somewhere to talk to them.
Morning, Mr. Shepherd.
Good morning, Anna. See my client on, but his screen is not on, so I'm not
Is
sure.
it Mr. Seeley?
Yeah, correct.
Okay, there you go. Oh, okay, I'll put you in a private room, Miss Lacy, with Miss Medellin.
Okay, thank you.
No problem.
Yes, I do. No, we're setting it for final pre-trial. No. No, we've already previously put the record on the offer on the record, so.
Judge,
Yes.
Ms. Donnelly said they're just looking for a final pretrial and jury trial date for Jessica Wilson.
Okay, was there an offer extended on that one?
Yes, Your Honor, at the previous pretrial conference, we did put an offer on the record.
Okay, sounds good. You can give the final pretrial date.
Okay.
Your Honor,
Yes.
did you, we got the dates for the final pretrial and jury trial.
We have all the files.
Okay.
So, Ms. Wilson, did you hear those dates?
No, I did not. I'm sorry.
March 22nd and April 5th at 8 a.m. here.
Okay.
All right, I'll talk to you later.
All right.
You're free to go, Ms. Wilson.
What was that?
You're free to go.
Okay, thank you.
You're welcome. Okay, Ms. Medellin, can you hear us?
Yes.
Okay. Ms. Lacy, was there an offer extended on her matter?
There was. The offer for Miss Medellin is for her to plead to an added count 2 of disorderly person jostling. That's contrary to MCL 7501671L. That is a misdemeanor, punishable by up to 90 days and or a $500 fine. In addition, she must undergo substance abuse evaluation and follow up with all recommended treatments. In exchange for that plea, we would dismiss the original count 1.
Okay, and so Ms. Medellin, you can either accept the plea or we can set this for a final pretrial or in a jury trial. At the final pretrial, you'll be required to appear in person, but the alleged victim will also be required to appear in person. And then you'll have more time to think about whether or not you want to accept this offer or not, or to see how it would impact your livelihood if you did enter a plea. Or you can decide if you want to proceed to trial at that time. Okay, ma'am? So how do you want to proceed now?
I guess I'm not positive.
Okay, so we'll set it for a final pretrial. That's going to give you time to think about it. Okay, ma'am?
Judge,
And then,
sorry.
I'm sorry?
I just have something to ask for the final pretrial.
Yes.
Yes.
I have spoken to the victim in this case, and he is actually living in Texas now. He is willing to come back for the jury trial, but I would ask that he be allowed to participate in the final pretrial by Zoom.
Okay, well then both the victim and the defendant can participate via Zoom for the final pretrial.
I have no problem with that.
Okay, so we'll set it for final pretrial, Ms. Medellin. You can appear via Zoom for the final pretrial, and the offer that was extended will remain open until that time, okay?
Okay, I'm just trying to understand. So does this mean he is trying to pursue charges with this?
The prosecutor is pursuing the charges. He is the victim or witness, okay? It's the prosecution who's pursuing the charges. So we're gonna set it for a final pretrial, give him an opportunity to appear so he can show that he is a willing participant and that he's ready to proceed to trial. You'll have more time in between now and then to think about the offer and see how it impacts your life. And if you want to take it or not, you have the right to have a jury trial, so you do not have to take an offer. And you should not take an offer just to get rid of the case. You should consider how it would impact your life before you take any pleas. Okay, ma'am?
Correct, yes.
Okay, so we'll set it for a final pretrial and a jury trial. Someone from my staff is going to give you the date now, okay?
Oh, okay, I appreciate it. Thank you so much.
March 29th at 8 a.m. for the final pretrial.
Okay.
And then April 5th at 8 a.m. for the jury trial.
Will I get something in the mail?
Yep, notice will go out in the mail, but just remember that your final pretrial, you can appear via Zoom such as you did today. Your jury trial, you're gonna have to appear in person, okay, ma'am?
Okay, and jury trial is when?
The jury trial is gonna be April 5th,
April 5th. Okay.
all right? Do you have any
Okay.
questions, ma'am?
Not that I can think of at the moment.
Okay, you're all set. We'll see you on March 29th.
Thank you, Judge.
You're welcome.
All right, have a good day.
Okay, same to you. Ms.
Thank
Lacy,
you.
I'm gonna handle Mr. Seeley before I put you in a private meeting room with Ms. Decker.
Okay.
We're on the record in the matter of the people of the state of Michigan versus Bradley Darlene Seeley. The file number here is J9438850. Can I have your appearance, counsel?
Yes, good morning, Your Honor. Eric Shepard here on behalf of Brad Seeley. He is also appearing via separate Zoom feed, and we would consent to the proceeding taking place over Zoom.
Thank you. Today was the date that was set for a motion to set aside conviction. And we got a copy of that. Did you get a copy of that, Ms. Lacy? Or did your office get a copy, I should say?
I'm looking for it right now, Your Honor.
It's to set aside a conviction from the 1995 for check non-sufficient funds, $100 to $500. And we've gotten no objection from the Attorney General.
If there's no objection from the Attorney General's office, then my office would take no position, Your Honor.
Thank you. Okay, and so, Mr. Shepard, did you want to address the court and let the court know what your client's been doing since the time of this incident?
Yes, certainly, Your Honor. First, there's two prongs that the court has to take a look at when it comes to setting aside a conviction. And the first prong is legal eligibility. And as the court has already intimated, that this is a case from 1995, misdemeanor file. My client certainly meets all the legal requirements in terms of it being an eligible offense. He's not been convicted of more than 3 felonies. He has no pending criminal charges. This is a non-assaultive and non-serious misdemeanor. So he has to wait 3 years from the last date of the conviction or incarceration or any probation that he received. So he's well beyond that, 3-year period in terms of legal eligibility. So the next prong is the circumstances and behavior of the applicant and whether that justifies setting aside the conviction and is consistent with public welfare. And in this case, Your Honor, my client is a very different person than who he was back in 1995. If the court takes a look at his history, he has certain offenses on his record from 1993, 94, and 95. After that, he has no charges, no arrests, no convictions, nothing on his record since that time. He's a family man. He is active in his church and in his community. He's a hard worker, works full time. I think he had some work obligations today, actually, which is why he's appearing with the Zoom feed and in his vehicle here. So, Your Honor, he certainly is well deserving and is exactly what the legislature had in mind when we expanded the law last year in 2021. So I'm asking the court to set aside this conviction, sign an order. I'm not sure if the court has its own prepared order, or I can certainly submit one to the court, Your Honor. Thank you.
Thank you. And I'm not sure that your client wanted to make his own statement. He obviously does not have to. You've advocated very well on his behalf, but I don't want to deny him an opportunity to say anything if he wanted to.
Do you want to say anything? Good.
Sure. Hoping you guys can hear me. I haven't done this Zoom by my phone before. Yeah, I think my attorney said it well. I'm a different person than what I was. Goodness, my math is terrible, but about 25 or 30 years ago. I made some terrible choices when I was 18, 19, and 20 years old and got myself hooked up with the wrong people. I'm a business owner now. I am a music pastor, music director for a church. I've been in the church world for 15 plus years, pretty heavy. And I love what I do. I didn't even know this was an option until about a year ago, talking to a friend, that I could have my record expunged. I had just kind of settled with, this is my past and it's part of who I was and part of who I am today. So yeah, thank you, Your Honor, for hearing this.
No problem. I think that you are a classic candidate for what the statute intended to do. And I find that based on the statements made by you and by your attorney, that you definitely meet the statutory eligibility requirements, and that it would be in the interest of justice to grant your application to set aside the conviction. So the order, Mr. Shepherd, is already in my file. I'll sign the order today and it'll be submitted to into the system, okay?
Thank you, Your Honor. Appreciate it.
No
Thank you, Your
problem.
Honor.
Mr. Seeley, did you have any questions?
No, I don't think so.
All right, thank you. You're all set and congratulations.
Thank
Thank
you.
you.
Have a good day.
You too. Let me put you in a private meeting room with Ms. Decker. What did I just do? Wrong thing. There we go. Okay, let's see. Okay, we're on the record in the matter of the people of the state of Michigan versus Alexandria Decker. File number is 22-00130. Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Okay, Ms. Decker, you're proceeding without counsel. That's correct?
Yes.
Okay, thank you. Today was the date that was set for a pretrial on a dog at large. How are we addressing this matter, Ms. Lacy?
Your Honor, Ms. Decker has been asked to provide me with some information with regards to rehoming the dog. I'm asking for an adjournment of 30 days so that she can get that information together and to me. I'm asking also that it be set at 8:30 in the morning as she's at work right now, and it was difficult for her to get the break time this late in the morning, but 8:30 she said would be better.
Okay, that's no problem.
We can do April 12th at 8:30.
Okay.
Okay, do you have any questions today, Ms. Decker?
I actually do. So after, so in the next hearing, after I submit this letter that was requested, would there be another like hearing after that, or would that kind of just be like the end of it?
Ms. Lacy? Ms. Lacy
as long as-
can determine if they're planning to dismiss or not.
Okay.
Okay, Ms. Lacy, I think I cut you off. Did you say something?
As long as I can get the appropriate documentation and verify it, then there would be no need for another date.
Okay.
Okay, do you have any other questions today, Ms. Decker?
No, I do not.
Okay, we'll see you April 12th at 8:30.
Okay, thank you.
You're welcome. Mr. Keithley, were you expecting Mr. Bond to appear?
No, Your Honor, this is a motion concerning discovery only, so I wasn't concerned or wasn't making arrangements for Mr. Bond's appearance, and I would waive his appearance for this hearing.
They were on the record in the matter of the people of the state of Michigan versus Ryan James Martell Bond. The file number is 21-03128 FY. Council appearance. I can't hear the courtroom.
It's muted.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Ryan Bond.
Thank you. Today was the date set for a hearing on a motion for protective order. Ms. Lacy, you filed a motion for protective order, that's correct?
Correct.
And Mr. Keeley, are you objecting to the protective order?
Your Honor, as I stated at the time at which Ms. Lacy first raised the issue of a protective order, we are still objecting to that.
Okay, if I have this correct, the parties, the defendant and the victim or alleged victim are siblings?
No, Your Honor, there's
No.
no relationship between the two of them.
Oh, okay, there's threats being made. Is that the issue?
That's correct, Your Honor. There's allegations that there were threats made on the defendant's behalf to the victim's brother.
Okay. So I'm not clear. If you can speak up a little bit, because it sounds like you're super far away, or maybe get closer to the mic. No problem.
If Your Honor will notice that in the report, I have no problem turning over the unredacted information to Mr. Keithley. And I have no issue if he can guarantee to the people and the court that that information will not be disseminated to the defendant. That is my issue here, and that's my issue in all the cases. The information, I mean, the Victims' Rights Act does indicate that the victim has the right to be reasonably protected from the defendant. So I have, again, no problem issuing this to Mr. Keithley, but it has to be with the conditions that it is not shared with the defendant himself. He should have no reason to share that information with the defendant.
Agreed. What is the reason or the basis for the objection, Mr. Keithley?
Well, Your Honor, I want to raise a couple of things as far as why I am objecting, and in terms of a response to the filing by Ms. Lacy. First of all, yes, I recognize that the complaining witness does have a right to be kept safe from the accused in this matter, and the court has already seen to that. There is a protective order in place. There isn't even an allegation that Mr. Bond has in any way violated the protective order, nor is there even an allegation that Mr. Bond has had any contact with the complaining witness in this matter prior to his arraignment, considering that this alleged incident took place in October. Ms. Lacy points out that, yes, the contact information, such as address, would be prohibited from disclosure under the Crime Victim Rights Act in a FOIA request. However, this isn't a FOIA request. This is a mandatory disclosure under MCR 6.201B2. And as far as this issue of contacts with a family member of the complaining witness by some other members of, I guess, potentially Mr. Bond's family, one, that is, even to begin with, fairly far attenuated. But beyond that, Ms. Lacy was informed of these alleged contacts back in February. And it appears that she was informed, I believe, from reading her motion on February 14th is when she was informed of that. I assume that's what it meant. The motion listed as October 14th of 2022, which I assume to be a typo. I assume that to be February 14th. And then she raised that with the court at our previous preliminary examination date on February 17th. We are now just over 3 weeks from the date at which Ms. Lacy was informed of this, and we don't have a report. We have nothing suggesting that there was any actual contacts here. I don't know whether the police investigated it. Ms. Lacy indicated that they were, and she indicates that in her report, and I'm not in any way suggesting she is saying something untrue to the court. But we don't have any substantiation of it. At this point, I don't believe there has actually been a showing of good cause for a protective order. There's a mere allegation of some tangential or attenuated contacts without any substantiation of that at all. So, Your Honor, that is the basis for our objection.
Your Honor, if I could just briefly respond.
You may.
Mr. Keithley is correct in that I don't have any follow-up from the detective that was requested way back in February. Unfortunately, I just don't have time to make sure that my detective does his job. That's his job. And I understand that, if I understand correctly, Mr. Keithley is saying that the crime victim's right to privacy only applies to a FOIA request, but that's not correct. And there's nothing in the Crime Victims' Rights Act that indicates that the victim's rights are only protected as to a FOIA request. The Victims' Rights Act reads that they are eligible for this type of privacy based on a showing that they have a reasonable basis to be, again, protected from the defendant. Nothing to do with a FOIA request. There's nothing that indicates that it's only related to FOIA requests. It doesn't indicate that they have, there's no reason for the defendant to have this information. Again, like I stated, Mr. Keithley and his office can use the information. The defendant has no reason to see it.
Your Honor, I'm sorry, this is a quote directly from the brief filed by Ms. Lacy. Under the Crime Victim Rights Act, certain personal identifying information of the victim may be kept confidential, and visual representations of the victim are exempt from disclosure under the Freedom of Information Act. This isn't a FOIA request. This is a discovery demand pursuant to MCR 6.201. And I'm not asking for the contact information. I'm asking for a full and unredacted copy of the police report.
And their position is they're happy to give you a full and unredacted copy. They just want to ensure that this victim's contact information is not shared or disclosed to your client. I think that's a reasonable request. I'm going to find that there is good cause to grant that request. They are to turn over an unredacted copy of the police report. And Mr. Keithley, you're to ensure that you do not disclose the contact information, that being the address and the phone number of the alleged victim, to your client. Relying on the basis that there's not been any contact does not mean that there's no reason to make any protective order. It may be that it's because they doesn't have a valid phone number to make the contact with. And so it would be your responsibility under this order to ensure that you don't share that information. So I'm going to grant the protective order. Did you provide me an order to sign, Ms. Lacy?
I did not, but I can.
Okay, I will request the order under the 7-day rule. Any additional matters for the record?
Nothing further for the people.
Ms. Lacy, can your office get that report to me by the end of today?
I don't have the report, Mr. Keithley, so no.
No, I mean the unredacted report.
Oh,
You
yeah,
do.
that, sure.
Okay, we're off the record on that matter then.
Thank you, Your Honor.
No problem.
Did you do Miss Barrett's case at all?
No.
More motion.
Mauer?
Well, listen. Okay. I get so clear. Information.
Have it. Okay. You doing Billborn this morning? Yep. I don't know, do you have any updated info from?
We have no information, so it's just to tell the judge that we don't know anything.
Okay.
Which won't surprise him. No.
Sure. Polycom working in the jail yet?
Well, I don't think we've had anyone show up from the jail.
Yeah, the whole internet crashed.
Yeah, we didn't have anything at all for this morning. We were like, and then 9:30 kicked back on. Thank God.
Mr. Keithley, are you representing Mr. Rucker?
No, Your Honor, Miss Donnelly is.
Okay, is she still in the courtroom, Miss Lacy?
She's in the hallway speaking to somebody.
Okay, sounds good.
Not yet. Oh, but she's still.
Talk to Rucker at all?
No, I don't need to talk to Rucker. I need more time. She's trying to find where she rehomed the dog and I.
You have a mask?
I don't have at the desk.
Yeah.
Okay, I'll go get one.
Well, so basically she was watching the dog and the first.
Ms. Donnelly, did you need to speak with Ms. Rucker privately?
No, Your Honor, I don't.
Okay.
So she. Or, yeah. Yeah. Figure out what it does. Randomly. So I just need more time to see if she can find out where it is. Okay. And then in the meantime, I'll try to do something. Yeah. Just think.
Okay. Is Ms. Nash in the courtroom?
Maybe.
Yes.
Okay, we're on the record in the matter, the people of the state of Michigan versus Jessica Rucker, file number 22-00067, counsel appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Jessica Rucker, who is appearing separately by Zoom.
Thank you. Today was a date that was reset for pretrial. We were resetting this matter so that the defendant can provide evidence that the dog has been surrendered. Did the prosecution receive the evidence that they were looking for?
No, Your Honor, and I'll defer to Ms. Donnelly at this time.
Okay.
Yes,
Ms.
Your Honor,
Donnelly?
it's my understanding that Ms. Rucker is trying to locate the dog. It belonged to someone, she doesn't know their name, but it was a mutual friend that asked her to watch the dog. So I was gonna be asking for, I believe this was adjourned previously. I would ask for another 30 days in order to locate that person.
Okay.
We can do April 12th at 9:30.
Okay, this matter will be adjourned to April 12th at 9:30. Ms. Rucker, did you have any questions for the court today?
No, ma'am.
Okay, you're all set.
Asking for final.
Judge,
Yes.
we have Kellen Bishop here in the courtroom in person.
Do they have an attorney?
Ms.
Yep, that's
Donnelly.
me.
You ready to proceed, Ms. Donnelly?
Yes, Your Honor. Oh, we can see.
Give me just a moment.
Schedule these at this time, arraignments at 1:30. Because the arraignment is at about the same time.
She doesn't do arraignments every day.
Oh, no.
We have a magistrate that does the arraignments every day.
Oh, okay.
You probably got arraigned on. She had arraigned on the weekend.
It was a Tuesday.
Was it Tuesday?
It was a Wednesday. It was a Wednesday.
Wednesday, okay, yeah. Wednesday's magistrate moment does the arraignments and they.
You said we had Kellen Bishop in the courtroom?
Yes, ma'am.
Okay. For the record, in the matter of the people of the state of Michigan versus Kellen Bishop, file number is 21-0250. Council appearance. Can you hear me?
You cut out at the end there.
Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Kellen Bishop, who is standing to my right.
Thank you. Today was the date that was set for a pretrial. How are we proceeding on this?
Your Honor, at this time, I do have an offer from the prosecutor. The plea offer is to plead his charge to the count of domestic violence with an agreement to complete both anger management and parenting classes. And the state would have no objection to sentencing under 769.4A. At this time, we would be requesting, defense would be requesting this be set for final pretrial and jury trial.
Okay. That's a complete and accurate understanding of this, or a complete and accurate recitation of the plea offer, Ms. Lacy.
Yes, Your Honor.
Okay, we'll set this matter for a final pretrial and jury trial, and the plea offer will remain open until the time of your final pretrial. Okay, sir?
Thank you.
We can do March 29th at 8 a.m. for the final pretrial. And we can do the jury trial April 5th at 8 a.m.
Okay, you'll get a copy of those notices to appear before you leave the court today. Do you have any questions today, Mr. Bishop?
I do not.
Okay, any additional matters for the record, counsel?
Nothing from the people.
No, Your Honor, thank you.
Thank you, you're all set.
Yeah. Just,
Another one of these.
Are we only waiting for Ms. Barrett to appear?
And Mr. Hilborn from the jail, but Mr. Abbott is here. He says he doesn't have any new information regarding an updated report.
Okay, for Barrett, you can prepare a bench warrant.
Did we do bachelor?
But we also haven't done Marcus Bachelor. That was another motion to set aside conviction.
He's not here, so I'm assuming his conviction does not, I gotta pull it up. He may not need to be here. He may not need to have a hearing, that is. Okay, this was the one that he failed to appear before, and Sean thought he might have sent it to the wrong address. So he resent it.
Yes, ma'am.
So I'm not sure why he didn't appear again.
Did we do Jessica Wilson?
Yeah, that was second final trial.
Let me see.
Okay, thank you.
Okay, I can't do anything with each other without him present. Is the jail gonna put Mr. Abbott's client on?
They were supposed to. He was on the jail list. I can call them.
Okay, Mr. Abbott, did you need to go on the record for anything, or were you looking for another date?
Guess we'll just need another date, Your Honor. We don't have an updated report yet.
Okay, you can give him a new date.
How far out?
A month, maybe?
Probably 30 days.
We can do April 12th at 10. is actually already scheduled for a review on the April 21st. So we'll just keep that one, April 21st at 8:30.
Okay, sounds good. Thank you.
Thank you, Your Honor.
Say 21st.
Yeah.
At what time?
It's at 8:30. It should already be in there. It's already scheduled.